Hello, everyone. This is our week 2 video. We're going to talk about several subjects today, including constitutional law of all things. But I think you'll see as we go through our discussion that constitutional law does affect the way people do business. So we'll get there shortly. I do want to make one note before we go any further. These lecture videos are critically important to our class. You have a syllabus. The syllabus lays out what pages of the book you have to read for that particular week. But the lecture, I think, is probably the most important thing of all in this class. I discuss concepts that are described in the book. I give examples of those concepts. I also give examples of how those concepts relate to the business world. And so the lectures really are an important component, maybe I think the most important component of this class. So you have to listen to the lectures. And I think there's two more additional reasons that I think the lectures are important. Number one, your attendance grade, 10% of your grade is going to be based on attendance. Obviously, this is an online course. You don't attend these classes, but you do watch the video. And Canvas keeps track of, and Zoom keeps track of, who has watched the video. So I'm going to go and look, I keep a record of that. If you haven't watched all the videos, your attendance grade is going to suffer. So keep that in mind. It's worth 10% of your grade, which is almost one full letter grade. So if you, for example, got A in everything in this class, all the exams, but you never watched any videos, you're going to be, your grade will be reduced by the fact that you haven't completed the 10% attendance requirement. So attendance means watching the videos. The second important thing about the videos is this. Most, if not all, of my exam questions come right out of what I say during these lectures. I might give you an example. For example, we're going to talk today about the Fourth Amendment. I might give you an example of how to apply the Fourth Amendment during our discussion today. And I might ask a question on the exam, which is exactly that question. And so if you've listened to the lecture and taken notes, the answer to that exam question is going to be easy. And you're going to get a good grade. You're going to be happy with your grade. So the lectures are critical to your success in this class. So don't think that they're just there as sort of an extra thing that you may or may not have to do. They're mandatory. They're required. Right? So they're not something that you can either do or not do at your leisure. You can't do that. Right? So watch the lectures. I'm here for a reason. I think I'm here to tell you and explain to you the necessary concepts that you need to know for successful completion of this class. Right? So don't discount the value of those lectures. All right. Well, let's start today with, as I always do, and by the way, this is a pattern you'll see. For every class, we'll have a PowerPoint presentation. Those PowerPoint presentations are also important because they contain many of the concepts that I'll be discussing with you during the lecture. And then you'll have the PowerPoint presentation to use to prepare for the exams. Right, so these are important as well. So look, I'd like to believe that everything I do in this class is important. If I post a PowerPoint presentation, that means it's important. If I show it to you during a lecture, it's important. All right. Okay, so let's take a look at this. Here's the PowerPoint presentation for today. All right, and here are the basic subjects. Let me start the slideshow for us, and we'll get rolling. All right, so here we go. Week 2, that's this week. We're going to talk about constitutional law. We're going to talk a little bit about the court systems. And I say systems because there's more than one court system in our country. And something called alternative dispute resolution, which is basically this. Often these disputes end up in court. There's a lawsuit. And, people have tried to find ways to avoid going to court because a court is time-consuming and expensive. Can we come up with an alternative way to resolve our dispute without having to go to court and both of us having to pay all of these expenses that are related to a court proceeding? So we're going to be talking about alternative dispute resolution, a way to avoid the cost of litigation. All right, so we've already talked about some of these things when we spoke together last week. I even showed you a short video from one of my favorite movies. And we talked about Sir Thomas More. and his view of what the law is for and what it means. And so, the law is a set of rules to help bring order to our society and our communities. It is both a way to keep people in line, if you want to think of it that way, but it's also a protection for the rest of us. So like in that video from that movie, one of the actors in the movie asked Sir Thomas More essentially to arrest a person, even though that person had not broken a rule of law. And Sir Thomas More said, no, I can't do that. So our world here in the United States is filled with different rules of law. They're there to prevent people from doing bad things and to protect the rest of us from, our government taking unfair advantage of us. The law protects us in many ways from our government. In fact, that's what our Constitution does. And so we'll talk about that in more detail. So, but first of all, I do want to talk about the U.S. Constitution and talk about what it does in its most basic form. Essentially what it does is it sets up our government. The Constitution lays out the three branches of government. You remember this even from high school. Our government is divided into three branches: the executive branch, headed by the president; the legislative branch, that's Congress; and the judicial branch, which is ultimately headed by the U.S. Supreme Court. There are three separate and independent branches of government. Each of them has its own separate function. And I think in its most basic way, it comes down to this. Here's how it works. The legislative branch, Congress, they make the law. They tell us what the law will be. They pass these laws, by vote. So they make the law. Legislative branch makes the law. The executive branch enforces that law. So, for example, the Department of Justice, the U.S. Attorney General, they are found in the executive branch of government. So if someone breaks a federal law, it's the Department of Justice that enforces that law, brings a case against that person, which ends up in court, and then the court resolves the dispute. So legislative branch makes the law, the executive branch enforces the law, right? And then when it comes to whether someone should be punished for breaking the law, that's the judicial branch's job. So I guess if you want to look at it this way, I think it's fair to do that. Legislature makes the law, executive branch enforces the law, and the judicial branch punishes for violation of the law. They have three separate and independent functions. They're not supposed to intrude on each other's function. And so the Constitution is broken down into these three basic articles. Article 1 describes the power of Congress. So it describes the legislative power of Congress, the power of Congress to make law. And in fact, in Article 1, there's a list of powers that are granted to Congress under the Constitution. They are called the enumerated powers of Congress. The executive branch, that's described in Article 2 of the Constitution. It describes the president. It describes the powers and the role of the president in our government. And finally, Article 3 describes the judicial branch, the powers of the judicial branch, and primarily lays out the power of the U.S. Supreme Court. It also, by the way, in Article 3, gives Congress the power to create other federal courts, which Congress has done. And so there is a separate federal court system, separate from state court systems. And we'll talk a little bit more about that in a little while. And so the U.S. Constitution establishes our government. And it does one other thing, which I think is interesting. So far, we've been talking about the federal government, the federal Congress, the president, and the federal court system, the judicial branch. What the Constitution also does is this. It says any power not given to the federal branches of government by the Constitution. So any power is not invested in one of the branches of the federal government. All the rest is left to the states. So the states retain all power not given to the federal government. And the idea was, I think, the founding fathers were thinking, we don't want to have the same experience we had with the English crown. We don't want to have a king. We don't want to have one all-powerful source of power. We want to divide that power up into different branches of government, and we want to make sure that the separate states also retain some power. So the last thing the founding fathers wanted was one supreme power source like a king. And so when it came time to write our Constitution, they made sure that they didn't have a king. In fact, powers were distributed among the branches of the federal government and also among the states. And so some people describe that as our federalist system of government. There's a federal government and there's separate and independent state governments. They have to act in cooperation. That was the idea. So far, it's worked. All right, so again, going back to the Constitution, one of the things it does is create these three independent branches of government, and which you probably also remember from high school or some earlier class you took in college, the system of checks and balances created by the Constitution. In other words, the founding fathers didn't want a king, that's for sure, but they didn't want any one branch of the government to have all the power. And so they created a way for one branch to put a restriction on the power of another branch. So all of the branches sort of have independent power, but they also restrict each other from going too far. And so here's some examples of that, these checks and balances system. And here's some, but we can, let's just pick out one or two and talk about how they work. So let's take, for example, Congress wants to pass a law. Congress does that all the time. The House of Representatives and the Senate, they vote, and ultimately they decide to pass a law. Well, that law isn't effective yet. That law has to be presented to the president, and the president decides whether to sign the law, and then it becomes a law, or the president can veto the law, which means the president refuses to sign. So think about this. There's a check on the power of the legislature, on the power of Congress. Even though Congress can pass a law, the president can prevent it from going into effect. Now, the founding fathers, they were worried about that too. They thought, well, wait a minute, isn't that like having a king? The Congress passes a law and the president says, no, I'm not going to sign that. That's not going to be a law. Well, the founding fathers said, well, we need to prevent the president from having that sort of supreme power. So if the president refuses to sign a law, vetoes that law, Congress can override the veto. But it takes more than just a simple majority in Congress to override the veto. It takes a supermajority. 2/3 of Congress has to agree to override the president's veto. So you can see that the president restricts the power of Congress by refusing to sign a law, vetoing that law. But Congress can then vote to override the president's veto. Right? So they're sort of restricting each other's power. Congress makes sure the president doesn't have supreme power because he can override a veto. Right? So there's an example of the checks and balances between the legislative branch and the executive branch. But what about the judicial branch? Well, they have a role in this too. So if Congress passes a law, the judicial branch has to determine whether or not that law violates the other provisions of the Constitution. So Congress might pass a law, someone challenges the constitutionality of that law, and the judicial branch has to decide whether that will be a law or whether it will not be a law because it violates the Constitution. So I'll give you a simple example. Let's say Congress passes a law that restricts people's ability to speak. In other words, it infringes on their right to free speech. Congress might pass that law thinking that's a good thing. There are certain areas of speech that should be restricted. So let's just, again, we'll use a real example. Let's say Congress passes the following law. No one can say any words that disparage any member of Congress. In other words, no person living in the United States can say anything bad about one of their representatives in the House of Representatives or one of their senators. Well, some people might say, wait a minute, that law seems to restrict my freedom to speak, which is protected by another provision of the Constitution, the First Amendment. And that person might bring that case to court, asking the court to find that statute is unconstitutional because it violates the First Amendment. Again, look what's happening. An act of Congress is now before the judicial branch. And the judicial branch has to decide whether or not that law violates the U.S. Constitution. And if the judge finds that it violates the U.S. Constitution, then that law is invalid and has no effect. So there's a check on the power of Congress. Now the check is contained in the judicial branch. The judicial branch has the obligation to determine whether any laws passed by Congress violate any other provisions of the Constitution. And so, as you can see from the slide, there's many examples of this. For example, the president might want to enter into a treaty with another country. And because the president sees that would be important to protect some U.S. interest around the world. Well, the president doesn't have the independent power to enter into a treaty. That treaty has to be ratified, voted on by Congress. And unless Congress ratifies that treaty, it doesn't become a treaty. Right? So there's another check on the power of the president. So there's, as you can tell from the slide, lots of different checks and balances between the three branches of the federal government. All right, here's some more examples in the next slide. We talked about the president being able to veto laws. But what about, let's take, for example, the Supreme Court. The judges who sit on the Supreme Court are appointed by the president. Right? So think about this. There's a separate and independent branch of government called the judicial branch, but it's the president who appoints the Supreme Court. So in a way, the president is affecting how the Supreme Court will work by deciding who's going to be the judges on that court. So does the president alone have the power to appoint the members of the Supreme Court, the members of another branch of government? Well, actually, no, because all the president can do is nominate judges for the Supreme Court. The nomination then has to be put before the Senate, has to be put before Congress, and only Congress can confirm the appointment. So although the president can nominate judges for the Supreme Court, it's Congress ultimately who has to approve that nomination, approve that judge. So again, think about it. The executive now has the ability, the power to affect who can sit on the Supreme Court, decide who can sit on the Supreme Court, but ultimately it's Congress who decides whether or not those people will actually sit. So there you have three branches of government interacting with each other. The president starts the process by nominating a potential judge for the Supreme Court. The Congress then has to generally hold hearings and determine whether or not they're going to approve that nominee to actually sit on the Supreme Court. So there you go. Again, another set of checks and balances between the three branches of the federal government. I guess before we move from this, think about something else that maybe you've heard about. The president has the power to pardon people who've been convicted of federal crimes. The Constitution gives to the president the right to pardon people. In other words, people who've been convicted of federal crime, the president has the power to erase that conviction like it never happened. And so that's a pretty important power that the president has. And it's almost unrestricted. So if you think about it, the person who was convicted, they were convicted in court. They were convicted in a federal court. So some member of the judicial branch found that that person was guilty of a crime and sentenced that person sometimes to jail. But the president has the power to say, no, I'm going to pardon that person. The person's released from jail and has no conviction. It's as though the conviction is erased. And so again, there's the judicial branch punishing someone for violating the law, and the president, nevertheless, pardoning that person, really letting them off the hook. So again, that's a check on the power of the judicial branch, and that check is held by the president. All right, so again, lots of different checks and balances. Here's a few more examples. All right. So, there's an interesting system that the founding fathers set up. And so it works sort of in tension. You have Congress, you have the president, you have the judicial branch, all of them acting independently, but all of them restricted and checked by the other branches of government. It's a really amazing system. That is our federal Constitution, the U.S. Constitution. So that's it in a nutshell. Now, the other thing that the U.S. Constitution does, and you've heard of the Bill of Rights, the Constitution gives us certain rights that our government can't take away. And so I guess, we're going to talk more about that in a few minutes, but I guess just sort of to set the general framework of how that works. As we've said, the Constitution sets up our federal government, but also places limits on the power of our federal government. And one of the ways it does that is to give us rights under the Bill of Rights. So, for example, and we'll talk more about this in detail, the First Amendment says, among other things, we have the freedom of speech. Well, it doesn't really say that. The First Amendment says Congress can't pass any laws restricting the freedom of speech. So if you really read the First Amendment, freedom of speech, and try to understand what it means, what it really says is the federal government, Congress, can't take away our right to free speech. And it's interesting the way it's written. Notice that it says Congress can't take away our right to free speech. And so we need to understand the implications of that. Remember, first of all, it's a restriction on the power of Congress. Now Congress can pass laws, but they can't pass laws that restrict our freedom of speech. So again, that First Amendment with some other pieces of the Bill of Rights, they are there to protect us from federal government power. In other words, Congress has the right to pass laws, but they don't have the right to pass laws that take away our freedom of speech. So we have the freedom of speech only in the sense that Congress can't take that away from us. So what we need to understand, and we'll talk about this again when we talk about the First Amendment, remember, if a private person takes away your freedom of speech, that doesn't violate the First Amendment. So for example, Facebook is a private company. Facebook excludes certain people from having accounts on Facebook because Facebook doesn't like what they have to say. Can Facebook do that without violating the First Amendment, freedom of speech? Yes, because we're only protected from our government taking away the freedom of speech. We're not protected from private people like Facebook taking away our freedom of speech. So if you think about, and we need to talk about this, because the Bill of Rights is set up in a way that it's intended to protect us from our government taking away certain rights. And that's all the Bill of Rights does. It doesn't protect us from other people, private people, non-government people taking away our rights. It only protects us. So the Bill of Rights is really, if you think about it at its heart, it is a set of rules to prevent the government from abusing its power. All right. Again, we'll talk more about that as we go. All right. So moving forward on our slide presentation, we pretty much talked about this last week. Why do we need the law? Well, we need a set of rules. Okay. We need a set of rules that create order in our society. I think that's probably at the heart and soul of what the law is intended to do. Right? We can't have anarchy and chaos. The only way to do that is to have rules, and have rules about things that you're not supposed to do, because those things might hurt other members of our society. So there's a whole bunch of laws out there. I think they're intended to prevent disorder and chaos. I think that's really why we need the law. All right. Now let's talk, I guess, maybe in some more detail about how the law is written and how it functions. All right. There's two basic and separate law systems. And here's the difference. There's civil law and there's criminal law. So in a way, we have court systems, both a federal court system and state court systems. Each state has its own court system. But all of those court systems are divided into two. Each has a civil side and each has a criminal side. So let's use a simple example. Someone steals my car. right? That's a violation of a law. Generally, that's a state law violation. I've committed the crime of, someone has committed the crime of stealing my car. Where do we put that case? Do we put it in the civil law part of the court system or the criminal law part of the court system? Well, it all depends on what we're trying to accomplish. If we want to punish someone for breaking a law, then we're going to be in the criminal court system. So the whole goal of the criminal court system is to punish people for breaking the law. So you know how this works. We've got lots of laws out there. Some of them are criminal laws. If you break the law, you're going to be subject to some kind of criminal punishment. So when we're trying to punish an individual for breaking the law, that person's going to end up in the criminal court system. So what the heck is the civil court system? Well, let's assume someone steals my car. That's a crime, and they can be prosecuted in the criminal court system. But it's also someone depriving me of my property. Suddenly, I don't have a car. Is there any way that I can get the value of my car from the person who stole it? And the answer is yes. I would go to the civil law system. I would bring a lawsuit against the person who stole my car and ask the court to make that person pay for taking my car, pay money. And so the goal of the criminal law system is to punish people for breaking the law. The goal of the civil law system is primarily to ensure that people are compensated for things that they've lost. So in my example, I would like to be compensated for the loss of my car. Not trying to punish the person who stole my car. We're trying to allow me to get compensation for what I've lost. I've lost my car because that guy took it. He should have to pay me for my car. So that's something we would resolve in the civil court system. And you've seen this, by the way, as you sort of look around and you read newspapers or you read internet reports. You've seen, in fact, famous cases. The one that sort of springs to mind is the O.J. Simpson case. He killed two people. He was accused of killing two people. And so he was brought to the criminal court system. And there was an attempt to prove that he killed those people so that he could then be punished for what he did. So when O.J. Simpson was prosecuted for those crimes, that occurred in the criminal court system. And the whole point of that prosecution was, in the end, a hope that the person who killed two people would be punished for what he did. Right? Well, it turns out O.J. Simpson was found not guilty in the criminal court. But you probably also know then that the families of the two victims who were killed, they sued O.J. Simpson. They wanted to be compensated for the loss of their children. So that case happened in the civil court system. So if you think about it, just the way the cases are named. So in the criminal court system, the case was called the People of California versus O.J. Simpson. So in the criminal court, it's the government prosecuting someone who's broken the law in the hope that that person will be punished for breaking the law. So the parties to that lawsuit are the government, California, versus O.J. Simpson. In the civil court case against O.J. Simpson, it was the names of the family members, the parents of the dead victims, who were suing O.J. Simpson so that they could recover compensation for the loss of their children. So their position was that now that their children had died young, they were deprived of having their children with them for the rest of their lives. And that is that's damage that they've suffered, and they should be compensated for it. And the only way to compensate someone who's lost a child really is to give them money. In other words, in this civil case, the jury would have to decide the value of those two dead people's lives. And they would have to require then that O.J. Simpson pay the value of those lives that he took away. And in fact, in the civil case, the parents succeeded against O.J. Simpson. And O.J. Simpson then was required to pay millions of dollars to the parents of the dead victims. And so there's the civil case. So cases often start out in the criminal court system, but can end up in the civil court system. Right? And of course, the civil court system is probably the one that you're most likely to run across in your business lives. So I can give you another example. You, for example, open a restaurant. Someone comes into your restaurant and they're injured because you forgot to clean up a wet spill that's on the floor. Right? Have you committed a crime? No, I don't think you'd end up in the criminal court system, but the person who's injured, they might want compensation. They might want you to pay compensation for the amount of their injury. So they would bring a case against you in the civil court system. Their hope being that the jury would recognize that the victim has been injured. There's medical expenses. There's all kinds of things that resulted from that injury, and the victim wants wants you, the owner of the restaurant, to pay for that. Wants to pay compensation for that injury. And so, if you think about it, the civil court system is a system of compensating people who've been injured. The criminal court system is intended to punish people who've committed crimes. Right? So, punishment versus compensation. There's the primary difference between these two court systems. Right? And so, are there federal civil courts? Yes. Are there federal criminal courts? Yes. Are there state civil courts? Yes. And there are state criminal courts. Right? So if you think about it, there's actually 4 court systems. 2 different branches of the federal court system, civil versus criminal, and 2 different branches of state court systems, civil and criminal. Okay. So that's how we that's how we resolve disputes when someone claims a violation of a law. But we really haven't asked this question: where does the law come from? What are those things that we call laws? Well, we've already talked about one source of law. That's the U.S. Constitution. What the U.S. Constitution says is the law. It's the law of the land. Statutes, those are laws passed by Congress and laws passed by state legislatures. States have also the right to pass laws. Florida has lots of laws passed by the Florida state legislature. So the law comes from statutes, which means just means a law passed by a legislature. Case law. So cases decided by courts. So when a court decides a case, that becomes a rule of law, so that courts in the future who have the same kind of case have to decide that case the same way. So in a way, decisions made by judges become law. That's a rule from that judge that we have to live by in the future. Administrative law, which is, by the way, a huge body of law. Here's where that comes from. The federal government, we'll use the federal government as our example. Congress has the power to make laws. Often what Congress has done is made a law, and then as part of that law, creates an agency to oversee the law. For example, Congress passed a law to make sure that the air that we breathe is clean. They passed a law restricting the ability of people to pollute. And Congress also provided that it would create an agency to watch over the conduct of people to make sure they're not polluting. So they created what's called the Environmental Protection Agency. So think about this. A law passed requires people not to pollute our world. And Congress created also an agency to make sure that people didn't pollute. And so the agency was given the powers to make all kinds of regulations. Right? So that's an administrative agency making rules about air pollution and water pollution, pollution of all kinds. And when that agency makes a rule, that's really a law. So rules passed by agencies of the government are considered laws. So if the EPA says, for example, you're a manufacturer of cars, that your cars can't pollute the atmosphere beyond a certain level. So restrictions on the ability of automobile makers to pollute the air. EPA has all kinds of regulations about that. They become law. So if a car manufacturer doesn't meet those EPA regulations, that manufacturer has broken a law and is subject to having the executive branch bring an enforcement action against that manufacturer. Maybe the manufacturer would be fined for violating that clean air rule. So administrative law, that represents regulations passed by administrative agencies. They become law. We have to live by those laws, and if we don't, we're subject to an enforcement action against us. Treaties are also laws. We talked about those. That's where one country, the US, agrees to a treaty with another country, which is then later ratified by Congress. Right? That becomes a law. All of us have to abide by that treaty. So for example, if our government enters into a treaty with another company that restricts certain things, in other words, certain things can't be imported or exported by either country. And we have treaties like that. So if someone in the US exports something in violation of that treaty, that person violated the law and is subject to some sort of enforcement action. Right? So treaties are laws. Executive orders, the president actually has the authority to sign executive orders. They have essentially the force of law. And so we see that once in a while emanating from the executive branch, executive orders. Right? They're also subject to being challenged in the courts of the judicial branch. Right? So there's some restriction on the president to just issue executive orders. Okay, those are a special area of the law, but they are the law. Right? And we have to be, and we're subject to those executive orders. All right. The next question, I guess, is there's this hierarchy of laws that existed in our country. In other words, some laws are more important than other laws. The most important law of all is the U.S. Constitution, is the supreme law of the land. If any other law conflicts with the U.S. Constitution, that law is invalid and unconstitutional. So, a federal law passed by Congress, if that law happens to be a violation of the U.S. Constitution, the federal law is invalid and is unconstitutional and can't be enforced. So all laws, whether federal or state law, they have to be in compliance with the U.S. Constitution. If they're not, they're invalid. So federal law is not the supreme law of the land. The U.S. Constitution is. Even federal laws have to comply with the Constitution, as do treaties. Treaties must also comply with the Constitution. Executive orders also must be in compliance with the Constitution. So let's just talk about these maybe in a little bit more detail. So we've talked about if a federal law is in conflict or violates the U.S. Constitution, the federal law is invalid. Right? What if an executive order is in conflict or inconsistent with a federal law? The federal law takes precedence over an executive order. So you can see a hierarchy here. Right? So if a federal law is in violation of the Constitution, the Constitution is supreme, the federal law is invalid. If an executive order is in conflict with a federal law, the federal law is supreme and the executive order is invalid. State law. If state law is in violation of any of the laws above it, executive orders, treaties, federal law, the Constitution, the state law is invalid. Right? So what we end up with is something called the supremacy clause. Federal law is always supreme over and above state law. And of course, that causes some real controversy in our country. So if a state passes a law that is inconsistent with a law passed by Congress, the state law is invalid. So the way the Founding Fathers have set up our Constitution is, yes, there is a federal government, and yes, the Founding Fathers made sure that the states also had power to act as governments. But if there's ever a conflict between state government laws and federal laws, the federal laws take precedence and the state laws are invalid. Right? So even though it's a shared system of power between the federal government and the state governments, in the end, the federal government is supreme over the state governments. And I think the Founding Fathers were thinking about this. Federal law passed by Congress, it applies to everyone in the country. It applies through all of the states. The idea, I guess, is that Congress felt that there should be a law and it should be applicable throughout the entire country. What the founding fathers were worried about is the federal government passing a law and then the states doing whatever they want, even if what they're doing is inconsistent with the federal law. And what the founding fathers were worried about was chaos. In other words, every state would have its own law, could disregard federal law, and we would end up with really chaos. And so they had to make a decision. They could have said, by the way, they could have done this. They could have said in the Constitution that state law is supreme over federal law. But they chose the opposite. Federal law is supreme over state law. So any state laws that are inconsistent with any federal law, those state laws are invalid and can't be enforced. Right, so there's our, again, another aspect of our federalist system, right? This sort of tension between federal government and state governments. But in the end, the federal government wins. Some people don't like that idea. Some people think that states should have all the power. And that's created all kinds of controversies in our courts over time. Sort of, if you look back in the history of our country, there have been many, many times when states have objected to the idea that the federal government is supreme. In fact, we had a civil war about that. The Civil War was all about that. The southern states felt that they should not be controlled by the federal government. They felt that they should be able to run their own economic system in the South and wouldn't have to answer to the federal government. And in the end, they seceded from the Union and then the Civil War. So you can see that this tension between federal and state governments has created problems for our country in the past. It even forced us to engage in a civil war, one part of the country fighting another part, all because the folks in the South didn't want to be under the thumb of the federal government. They felt that states' rights were more important than the federal government's rights. And so there we had it. Okay. I guess the one thing we haven't mentioned, we've talked about federal law, we've talked about state law, but what about something called international law? In other words, is there some place we can go? Is there some court we can go to if we have a dispute with another country? And the answer right now is no. Or at least there's very few such courts. There's the International Court of Justice, sometimes deals with criminal offenses committed somewhere in the world. And those offenses can be then tried in one single court that sits in The Hague. But that's a very special court. That deals with really war crimes. Otherwise, there's really no place to go. If we have a dispute with another country, and you know, let's put this in the business context. And this happens all the time, where you have a US company. You enter into a contract to buy things from a German company. And you pay the money up front to the German company and they don't deliver the goods. And so now you've suffered damages. You've been damaged as a result of the German company breaking your contract. All right. If you want compensation for that kind of damage, you would go to the civil courts. Yes. But what court do you go to? You're dealing with a German company. Can you bring a lawsuit in the United States against the German company? You could, except the courts of the United States, they don't have jurisdiction over a foreign entity like a German company. Where you go? Can you go to the German courts and sue the German company there? You probably could. You could use their court system to try to get compensation from them, but you'd have to go to Germany to do it. And of course, that can be very complicated. Probably you don't know German law. You don't know any German lawyers. And to bring a lawsuit in Germany would be a very difficult thing for you because, if for no other reason, the language barrier. And so countries who've had these problems have tried to come up with a way to resolve their disputes, because otherwise it's very difficult to resolve those disputes. And so the best way to do that seems to be, based on experience, is to have a treaty. So if you think about it, could the United States enter into a treaty with Germany that deals with what happens when a German company and American company have a dispute, a legal dispute over, let's say, a contract. How are we going to deal with that? The treaty might have provisions that deal with how we're going to resolve that. All right, so what you have is then the creation of an international body of law. But if you notice something, international law is voluntary. What does that mean? That means that, for example, treaties, both countries have to agree to the treaty. And then they agree that certain rules will apply if there's ever a breach of contract between a US company and a German company. We can't force Germany to accept our laws. The only thing we can do is ask Germany if they agree to resolve these disputes in a certain way. And so we can't force other countries to have laws like ours. We can only ask them to participate in some sort of treaty agreement. So they have to voluntarily agree to a certain set of laws that might, or rules that might encompass their citizens. And so you can see that when we talk about international law, there is no international world court where we can resolve our disputes. It doesn't exist. The only thing we can do when we have disputes with people from other countries is try to enter into an agreement, a voluntary agreement, which we're going to call a treaty. Right? So international law is a very strange and different thing from what we have in the US. So in the US, our Congress passes laws and they apply to all of us in the country. Congress can't pass laws that affect people in other countries. Congress doesn't have that power. Congress can only act within the boundaries of the United States. So if we want to resolve disputes with other countries, the best way to do it, the most efficient way to do it, is to enter into a voluntary treaty with that other country, right? So I think that's what I mean by when I say international law is voluntary. We can't force legal rules on other countries. We can only do it if they agree, if they voluntarily agree to enter into a treaty, right? Okay. We've touched on this. We haven't used this word, stare decisis, this Latin phrase. But what this means is when courts decide cases, then later cases, those courts have to decide the same way. So when a court creates a rule in one of its decisions, that same rule will apply to future court cases. Right? And that's called stare decisis. Right? In other words, if the court decides a particular issue, the next court who faces the same issue has to decide it the same way. That way we bring order to our court decisions. Right? That's this thing called stare decisis. You may have heard that or read about that. That's what they mean. All right. One court passes or makes a rule. Later courts dealing with the same issue have to apply the same rule. It's not like a Congress has passed or a legislature has passed a law, but in a way, a court has created a law by ruling in a certain way. Future courts have to follow that ruling. All right. Okay. Okay, we've mentioned the supremacy clause. Right? That means that federal law is supreme. Federal law takes precedence over state law. That's all that means. It's the supremacy clause. Right? There's also here something, if you look on the slide, called the preemption. So there's supersession. That means federal law is supreme over state law. Preemption is a little different. There are some times when Congress decides only Congress can regulate a certain thing. So an example of that is OSHA, the Occupational Safety and Health Act. It's a set of rules that regulate safety in workplaces, like construction zones. It's a federal law that lays out all of these rules that people have to live by when they're on a work site. Safety rules. Congress decided that there should be only one set of safety rules that apply across the whole country. And so Congress essentially did this. It's called preemption. Congress has preempted the ability of the states to have separate safety laws for workplaces. So Congress has the power, once it passes a law about safety in workplaces, it says in that law that the states can't separately regulate workplace safety. We're not going to allow that. So Congress can preempt the states. Right? These are pretty rare events. Doesn't happen very often that Congress does that, but Congress does have the power to do that under the Constitution. Okay. Now let's talk about, what I'd like to do now is start talking about certain and specific powers given to the branches of government under the Constitution. Remember, we talked about this. When the Constitution set up the legislative branch, it gave to Congress a certain list of powers that Congress has. For example, Congress has the right to decide what happens on federal property. Congress has the ability to create immigration laws. One of the most important powers of Congress is the commerce power. That's this slide. And if you think about it, when the founding fathers wrote the Constitution, we had a growing country, right? We were expanding, and our states were trading goods and services with each other. So, wheat grown in Ohio might be sold to people in Maine. And Congress, or the founding fathers, were worried that this could lead to real disputes between states. In other words, when people are engaging in, when states are engaging in commerce with each other, they're engaged in business with each other, disputes could arise, problems could arise. And so the founding fathers gave Congress the power to regulate commerce that occurs between the states. The idea, I guess, being that, again, we want to avoid discord. We want to avoid disputes. We want an orderly society. So maybe we need to have one place where rules are determined as to how commerce should operate between the states. And the founding fathers gave that ultimate authority to Congress. So Congress has the power to regulate any activity that has a substantial effect on interstate commerce. That's a huge power. Probably most laws passed by Congress are based on the commerce power. Right? So if you think, and we can talk about some examples. For example, there are federal laws passed by Congress that regulate illegal drugs or make certain drugs illegal, like cocaine, for example, and heroin. So Congress has passed a law restricting the use and sale and transportation of certain kinds of drugs. And some people then ask this question: what gives Congress the right to regulate drugs? Because if you read the Constitution, nowhere in that document is the word drug. Nowhere does it say Congress has the right to regulate drugs. And so how is it that we have this big set of laws, federal laws, regulating dangerous drugs like cocaine and heroin? Where does Congress get the power to do that? Well, the answer is the commerce power. So here's how the argument goes. Buying, selling drugs, transporting drugs, that inevitably would involve drugs passing over state borders. If you look around the country and you just think about cocaine isn't grown in the U.S. The only way for cocaine to get to any state in the United States is if it passes over the state, at least one state border, if not one international border. Congress has the right to regulate not only interstate commerce, but foreign commerce. That's the commerce power. So isn't it absolutely true that cocaine found in the U.S. had to cross at least one international border or one state border? Yes. So is the movement of cocaine in the U.S. something that occurs between states? The answer is yes. Because it's an activity that involves interstate commerce, Congress can regulate it. So all those drug laws, those federal drug laws we have, those are authorized by the commerce power. The Affordable Care Act, it's a regulation of health insurance. Nothing in the Constitution says anything about health insurance. But does the cost of health insurance have an effect on interstate commerce? If the answer is yes, then Congress can pass laws regulating health insurance, which Congress did. And so the commerce power is an extremely important power of Congress. Congress has the power to regulate interstate and foreign commerce. Right? So the commerce power, again, you can't really talk about constitutional law, federal constitutional law, U.S. constitutional law without talking about the commerce power. And by the way, it raised another question in our, a long time ago in our history. People asked this question. Well, if Congress has the power to regulate interstate commerce, in other words, business occurring between the states, do the states also have the right to regulate interstate commerce? In other words, is that solely a power of Congress, or is that a power shared by the states? It's really a good question, because the Constitution doesn't really say what the answer is. But our Supreme Court ruled a long time ago that Congress, yes, has very broad power to regulate interstate and foreign commerce, but the states also have a little bit of power to regulate commerce between that state and another state. And that's called, strangely, the Dormant Commerce Clause. The Dormant Commerce Clause is the state's ability to regulate interstate commerce. So can states regulate commerce with another state? Yes, but they can't create an undue burden on interstate commerce. And by the way, this is a very complicated area of constitutional law. People have written books, big books, just on this Dormant Commerce Clause, the ability of states to regulate interstate commerce. And so it's probably an area we can't spend a lot of time on. All you need to know is there are laws out there passed by Congress that regulate commerce, but there are also state laws out there that also regulate interstate commerce. And that's, I think, as far as we need to talk about the Dormant Commerce Clause. All right, so I guess more important for us in this class is Congress's ability to regulate commerce. So think about this. Maybe it's a good question, and maybe it puts into operation some things we've talked about and learned so far. Some people ask this question: can Congress regulate the internet? In other words, could Congress pass laws that restrict certain operations on the internet? And so I guess the question leads to another question. Has Congress been granted the power under the Constitution to regulate the internet? Well, it's probably no surprise to you that if you read every word of the Constitution, guess what word is not in there? Internet didn't exist at the time the Constitution was written. It didn't exist 50 years ago. So how in the world could Congress regulate the internet? I think the answer would be this. Does commerce occurring over the internet inevitably pass over state lines? In other words, if I put a website up on the internet and I'm selling things, is that website accessible in all 50 states? I would think the answer is yes. So if I'm doing business over the internet, isn't it necessarily true that my business will have an effect on interstate commerce because it crosses state lines, electronically? I think the answer is yes. So could Congress regulate the internet because it has an effect on interstate commerce? I think Congress could. Congress has rarely done that. Not because it doesn't have the power to do that, but because it doesn't have the will to do it. In other words, it doesn't want to. But if Congress wanted to regulate the internet, it could under its commerce power. So what we have to do is, I guess, wait and see what happens in the future. Are there things happening on the internet that are bad things? And if they're bad, shouldn't Congress pass a law against it? For example, are all kinds of people being fooled and defrauded over the internet, being sold things that the person on the other end never intended to deliver? I think it happens probably thousands of times a day. Those are bad things. And usually what happens when something bad is happening, Congress passes a law against it. So I think the fact exists that certain kinds of bad things are happening over the internet. Congress could regulate the internet, but hasn't decided how to do that. So, I guess that's something to look for in the future. Clearly, lots of commerce is done over the internet. The internet reaches all 50 of our states. Congress has the power to regulate that kind of activity. Congress just can't figure out how to do it and whether it wants to do it at all, whether we should have a free and open internet. A lot of people believe that's true. So that might be the reason Congress has not tried to regulate the internet, but it could. So something to watch for. All right, so there's the commerce power. Now I'd like to talk about certain aspects of the Bill of Rights, the first 10 amendments to the Constitution. Remember, I've sort of mentioned this, and I've done it this way. What the Bill of Rights does primarily is it says to the government that the government can't do certain things. For example, we talked about the First Amendment. The government can't take away your freedom of speech. And so those amendments are kind of written in the negative. What they do is they tell the government what it cannot do. So let's take the First Amendment, for example. That's our next slide. All right. Now I've written here, the First Amendment protects the freedom of speech, the freedom of the press, the freedom of religion, and the freedom to assemble. How does it do that? It does it by prohibiting the government from restricting any of those things. So the First Amendment doesn't say, you have the freedom to say anything you want. It doesn't say that. It says Congress cannot pass any laws restricting your freedom of speech. So in a way, if you think about it, the First Amendment is a limitation on federal power, a limitation on government power, a limitation on the government's ability to regulate certain things. So the First Amendment limits the government's ability to regulate our speech, what we say. So there's the First Amendment. Again, it's written in the negative. And by the way, if you read the words of the First Amendment, it says Congress shall pass no law restricting the freedom of speech. It doesn't say anything about the states passing laws. So if the First Amendment says only Congress can't pass laws restricting the freedom of speech, could the states pass laws restricting the freedom of speech? And that was an issue that was decided by our Supreme Court a long time ago. And what the Supreme Court said, what the First Amendment means is no government, federal or state, can pass any law restricting the freedom of speech. And again, notice how it's written. It's the government that can't restrict your freedom of speech. People who are not the government, so private entities, can restrict your freedom of speech without violating the First Amendment. So what do I mean by that? Well, here's an example. Let's say, I own a business, and I've realized that what's happening sometimes is when my employees go home after they work, they go onto the internet, social media, and they start writing bad things about me and about the business. And you know what? That's hurting my business. So again, hypothetically, next day, I create a new rule for my employees. Here's the new rule. No employee can write anything bad about our business or about me on the internet. And of course, the employees then might say this, wait a minute, that violates my freedom of speech. And strangely, however you might feel about that, the fact is that's not right. That's wrong. Remember, I own the company. I'm a private person. I'm not the government. Can I restrict your freedom of speech without violating the First Amendment? Yes, the First Amendment doesn't apply to private companies that are restricting the freedom of speech of their employees. So my employees could not claim that their First Amendment rights have been violated. Because remember, the First Amendment only protects us from the government taking away our speech, not private entities. So when Facebook decides to cut off someone's Facebook account, that person can no longer speak on Facebook. Has Facebook taken away their freedom of speech? Yes. Has Facebook, however, violated the First Amendment? No, because Facebook is not the government. Right? That's an incredibly important distinction that a lot of people, frankly, don't understand. Most people, I think, probably believe that anybody who tries to take away their right to speak is violating the First Amendment. That's not true. Only when the government takes away our speech is the First Amendment violated. And so the First Amendment only protects us from our government taking away our freedom of speech. And that's important, an important thing to remember. And by the way, an important thing to remember for my exams. Often I will ask questions on my exam where a private employer restricts the ability of its employees to speak on the internet. And I ask the question, could the employees claim that their First Amendment right to freedom of speech was violated? And the answer is no, they can't, because their employer is not the government. So this is an important concept. And I bet you if you walk down the street and asked 100 people if they really understood the freedom of speech under the First Amendment, probably most of them would not. Most of them would think that any restriction on the freedom of speech violates the First Amendment. That's not true. And there's some other things that aren't true as well. If you read the First Amendment, it sounds like the government can't do anything that restricts your speech. Anything. Government can't pass any law that restricts my freedom of speech. And many times, cases have ended up before our US Supreme Court, where the Supreme Court has been asked, could you please explain to us what the First Amendment really means when it comes to freedom of speech? And here's what the Supreme Court has said. Over time, it's taken many years for them to develop their decisions about the First Amendment. But here's the way the history is sort of run. Because the words of the First Amendment seem to be pretty clear. The government can't do anything that takes away your freedom, even a little bit of your speech. Can't take away even a tiny bit of your freedom to speak. The Supreme Court has said over time, that's not quite true. In other words, there are certain kinds of speech, certain kinds of things that people say that the government should be allowed to regulate. That seems to run counter to the First Amendment. The First Amendment says the government can't take away even a tiny bit of your speech. The Supreme Court said that can't be what the Founding Fathers meant. They must have meant that there are certain kinds of speech that is bad. And so the government should be able to regulate it. So, for example, another example, we have a federal law that makes it a crime to threaten the president. So, the statute, the law reads something like, you can't utter any words which are physically threatening to the president. I'm going to kill the president. I'm going to hurt the president. If I say that and I really mean it, that's a violation of federal law. Some people have looked at that law and said, hey, wait a minute. That violates the freedom of speech. That law is passed by Congress, and they're taking away from me certain words that now I can't say without breaking the law. Don't I have a right to say anything I want? Even I'm going to kill the president. That seems to be something that the First Amendment should protect. It says right in there, the government can't pass any laws restricting my freedom to speak. And yet this law says that I can't speak certain words. Doesn't that violate the First Amendment? And that case has been before the Supreme Court. And the Supreme Court has said that the First Amendment doesn't mean every single bit of speech is free and it can't be regulated. Certain kinds of speech are harmful. And therefore, the government should be allowed to regulate the kinds of things that are harmful to other people. So we'll take another example. And so that law that you can't threaten the president, that was found to be constitutional, doesn't violate the First Amendment. Here's some other laws that were passed. There's laws against false advertising. It defrauds people. It causes people to spend money on things that are fakes, false advertising. Well, people have said of those laws, wait a minute, isn't advertising a kind of speech? I'm talking about my product. It's a form of speech. And the courts have said, yes, it is a form of speech. How can the government then restrict what I say in my advertising without violating the First Amendment? I think it's a, it's a reasonable argument. So in other words, here's the problem. I'm lying about my product. It's false advertising. I might argue this. Well, it doesn't matter if it's false. It's my speech, and the government must leave my speech alone. I should be allowed to say anything I want without being regulated by the government. And when the government passes a law against false advertising, they're regulating my speech. They're telling me what I can't say. And so people have brought that case to the Supreme Court. And the Supreme Court has had to decide this. Is every kind of speech protected by the First Amendment? And again, the Supreme Court said, no. False advertising is harmful to other people. It does harm. Therefore, the government should be allowed to regulate it. So there's, if you think about it, if you really look back over the history of all of the First Amendment decisions made by the Supreme Court, slowly over time, the Supreme Court has really weakened the protection we have under the First Amendment. Time and again, they come up with certain kinds of speech that are so harmful that the Supreme Court thinks the government should be allowed to regulate that. So for example, pornography, that's a form of speech, a form of expression, says the Supreme Court. Do we have laws against pornography? In some states, we do. And so the people who make pornography, they argue that violates the freedom of speech. The government is regulating certain forms of expression and speech. And again, the courts have taken the position that, well, that's a harmful form of expression. And therefore, the government should be able to regulate it to some degree. So again, you can see over time, the Supreme Court and other courts have found certain kinds of speech to be so harmful that the government should be allowed to regulate it. And that bothers some people. In fact, it bothers me a little bit. The idea that even though the First Amendment essentially says, all speech should be free from government restriction. Nevertheless, the Supreme Court over time has found certain areas where the government can restrict certain kinds of speech. Isn't that contrary to the First Amendment? When the Founding Fathers wrote the First Amendment, they could have written something like this. The government can't regulate speech that is not harmful. In other words, they could have written into the First Amendment the ability of the government to regulate harmful speech, but they didn't. They wrote it a different way. They wrote it as if it sounds that all speech is free and can't be regulated. And so, should the Supreme Court be reducing the protection of the First Amendment by finding that government under some circumstances can regulate certain kinds of speech? Does that do an injustice to the words of the First Amendment? It might, but it raises another question, maybe even a more difficult one. Does it turn out in the end that the people who are deciding what I can and cannot say, the members of the Supreme Court, are they the ones deciding what I can and cannot say? In other words, are they the ones deciding what the First Amendment means? And guess what? Those Supreme Court judges, they're appointed. They're not even elected by me. I don't even get to vote for the people who are deciding what the First Amendment means. And that bothers some people. It bothers me a little bit that in a democratic political system like ours, shouldn't we have some say over the people who decide what our rights are? And we have no say over who's on the Supreme Court. Those people are appointed by the president and confirmed by the Senate. So when it comes to the nomination of Supreme Court justices by the president, the only thing I can do is vote for a different president next time. I have no say over who ends up on the Supreme Court. Anyway, the First Amendment, again, I think it's important for you to recognize. So why is this important for business students? Well, actually, that flows from one of my examples. Remember what I said? If you own a private business and you don't like what some of your employees are writing on the internet, could you pass a rule that says they cannot write anything bad about you or your business on the internet? Could you make that a rule of your business? Yes, you could. Would that violate the First Amendment? No, because you, the employer, you're not the government. Only the government is restricted in what it can do under the First Amendment. All right, so you might want to have that conversation with your employees. It might be that some employees are saying some very damaging things about your company, which maybe aren't true. And so you'd like to prevent that from happening. Something you might have to consider someday. I think more and more, because social media is kind of taking over the, our lives, it becomes a real problem for businesses. Your reputation is important. Sometimes your reputation is affected by what people write on social media. So something to think about. Okay. I've thrown this on. This is probably not really necessary for us, but it's an example of advertising as speech. We talked about the Supreme Court has said that advertising a product is a form of speech and that the government can regulate it to some extent. And this is what the Supreme Court has said. If the government wants to regulate advertising, it has to pass a test. And this is the test. It's from a case called the Central Hudson case. All right. So can the government regulate advertising? Yes, if, and even lawful advertising can be regulated. Even non-deceptive advertising can be regulated if the state has a substantial interest in, what's being advertised, has a substantial interest in protecting its citizens from certain kinds of advertising. Right? And that its regulation doesn't cut off too much speech, is narrowly tailored. In other words, doesn't cut off all speech, just regulates a little bit of speech. Then it's probably okay. So can the government regulate certain kinds of advertising? Yes. Even advertising that's not false can be regulated. Right? So I don't know that we need all of this technical stuff. I mean, this is actually from a Supreme Court case, and it's the legal standard to be applied to regulation by the government of advertising. I think that's probably more than we need to know. All you need to know, I think, is that if you're in business someday and you'd like to advertise your product, you might be subject to some government regulation of how you do your advertising. For example, as a lawyer, I'm a lawyer. Do sometimes lawyers advertise their services? Of course they do. They're all over the place. You see them on billboards on the highway. You see them on television. You see them on the internet. It seems like lawyers are everywhere. In fact, you're sick of hearing about lawyers. They advertise a lot. Can the government regulate lawyer advertising? Well, here's what happens. As a lawyer, I have a license to practice law from Florida, the state of Florida. It's given to me by the Supreme Court of Florida. And the Florida Supreme Court has passed some rules about what can or cannot be in lawyers' advertising. We don't have to get into the specific rules, but the ultimate question is that government regulation of lawyers' ability to advertise their product? It is. There are certain restrictions on the ability of lawyers when they advertise. Some lawyers have argued that violates the First Amendment. The Supreme Court of Florida is a branch of the government. And those rules passed by the Supreme Court, they restrict the ability of lawyers to advertise in certain ways. Doesn't that violate the First Amendment? And some of those lawyers have succeeded. And I'll tell you why. There was a time not too long ago when lawyers were completely restricted from advertising, couldn't advertise at all. And that rule, again, a rule of the Supreme Court, was challenged in court, and that rule was found to violate the First Amendment. So completely banning lawyer advertising is unconstitutional, violates the First Amendment. But since that time, the courts have ruled that, however, certain kinds of lawyer advertising might be regulated by the government. And those rules still exist. And so there's another example where some lawyers said, I should be completely free in my ability to advertise any way I want, because that's my right under the First Amendment. But the courts have come back and said, no, you don't have an absolute right to say anything you want. The government, in some instances, like when it comes to lawyer advertising, can restrict certain kinds of expression. Right, so again, you have this this conflict between the words of the First Amendment, which seem pretty clear. The government can regulate no speech. And then you have the courts over time saying, well, they didn't really mean that. There are some forms of speech that can be regulated. All right. And here's some more examples of that on the next slide. Here's the kinds of speech that the Supreme Court has ruled can be regulated to some degree by the government. All right. So we talked about, child pornography, for example. That's bad. And so but it's a form of expression that's protected by the First Amendment, but the government can regulate it to some degree. In fact, it can be it's a crime to possess child pornography. So that form of expression is absolutely illegal. And the Supreme Court said that doesn't violate the First Amendment. Certain kinds of words, like fighting words, like yelling, fire in a crowded auditorium and everybody runs away and gets hurt, maybe running out, right? So those words, but people have said, wait, I should be able to say anything I want. Isn't this a violation of the First Amendment? The Supreme Court said, no, certain kinds of harmful words can be regulated. We talked about obscenity. Defamation is when you lie about someone, you make a false statement about someone. Well, shouldn't I be allowed to say anything I want without being regulated by the government? The Supreme Court said no. If you make a false statement about someone, they can sue you in court. And so because the government runs the court system, these claims of defamation, that's a limitation on your ability to say certain things. What you now can't say is a false statement about another person. Right? So that's the law of defamation. So again, a restriction on your right under the First Amendment. The courts have found, yes, certain words are so harmful, they can be regulated. All right. That's our First Amendment. Now I'd like to jump over to another of the Bill of Rights, the Fourth Amendment. The Fourth Amendment primarily deals with this. It says this: we are protected, all of us, from unreasonable searches and seizures by our government. In other words, the Fourth Amendment protects us from, for example, the police coming into our houses and searching around for evidence of crime. Right? Fourth Amendment says those kinds of searches are unreasonable and therefore unconstitutional. Right? So first, a little bit of history. You can imagine why that's included in our Constitution, because the Founding Fathers suffered under the British king, who would send his troops in to search the houses of people living in the colonies to look for, people who might be thinking about revolution, thinking about breaking from the, British government. And so the colonists were victimized by these searches by the British Crown without any search warrants or without any protections at all. So the Founding Father says, that's enough of that. We're going to write a constitution and we're going to include this Fourth Amendment, which means this. If we boil it down, if we think about it in the terms that the Supreme Court has told us, we should think about it. Here's what the Supreme Court said. Under the Fourth Amendment, the government cannot search places where we have an expectation of privacy without a search warrant. So if the government officials, like law enforcement people, want to come into our house and look around for evidence that we've committed a crime, they have to have a search warrant, which means they have to go to a judge. They have to explain to the judge that they've gathered certain evidence and believe that there's probable cause that there's evidence of crime inside that place that they want to search. Right? So the Fourth Amendment protects us from government searches that occur without a warrant. Now, are there some instances when the government doesn't need a warrant? Yes, the Supreme Court has created these exceptions. Circumstances when an actual search warrant is not required. And let's talk about one of those. It's called the automobile exception. So here's what the Supreme Court said. If a police officer, who's again a member of the government, wants to search a place where a person has an expectation of privacy, like inside your car, the police generally need a warrant, but because it's a car and because cars can just drive away, we're going to make an exception. Here's what the Supreme Court said. Before a police officer can search inside a car, the officer has to have probable cause to believe there's evidence of crime in that car. But the officer doesn't have to stop and go get a search warrant, because by the time the officer does that, the suspect will drive away. So what the Supreme Court has created is an exception to the warrant requirement under the Fourth Amendment for automobiles. But most other kinds of places, before the government can search, they need a search warrant. We have to go through a judge, and the judge has to make an independent decision about whether there's justification for doing a search. Right. Now, here's the critical thing. Remember what we said about the First Amendment. We are only protected from the government taking away our speech. Under the Fourth Amendment, we are only protected from the government searching our private places. Right, so here, I've asked this question on exams in the past, so get ready. There's a question right out of one of my exams. You're at school, maybe taking a class one day, and without your knowledge or permission, your landlord, because you lease an apartment, your landlord searches your apartment, finds marijuana, calls the police, gives the marijuana over to the police, and the police arrest you for unlawful possession of marijuana. Have your Fourth Amendment rights been violated? The answer is no, because the person who did the search was not a member of the government. It was your landlord. Even though your landlord searched an area where you have a right to privacy, even though your landlord did it without a warrant, the Fourth Amendment doesn't apply because your landlord is not the government. So once again, you're protected from unlawful searches and seizures, but only when they're done by the government. If a private person searches a place where you have a right to privacy and does it without a warrant, your Fourth Amendment rights have not been violated. This is a critical distinction for you. All right, so like the First Amendment, the Fourth Amendment only protects us from certain government activity. Now, why in the world in a business class are we talking about the Fourth Amendment? Well, here's why. There have been many instances where a government law enforcement person suspects that a business has been breaking the law. So we'll use a basic example. Let's assume that one of the criminal investigators from the Internal Revenue Service suspects that your business is cheating on its taxes. And so the criminal investigator knocks on the door of the business and asks to come in and search for the tax records of the business. Can the criminal investigator search for those records without a warrant? The answer is no. So they knock on the door, you answer. The investigator says, we want to come in and search for all your tax records. Can you say no? Yeah, you can say no because they don't have a warrant. They don't have a search warrant. All right, the only way they can get in then is if you give them consent to come in. And lots of people do that, not knowing that they can say no to those investigators. Could you say no, you can't come in? Yeah, you can say no. But some business people think they have to let them in. Once you consent to letting them in, the Fourth Amendment doesn't apply anymore. They can look around, and you can't later claim that your Fourth Amendment right was violated. So yeah, it happens all the time. The law enforcement people want to come in and search businesses for evidence of crimes. So as a business person, do you need to understand your rights under the Fourth Amendment? Yes, you do. It's critical. Can you say no, you can't come in without a warrant? Absolutely. That's what you should say. No, you can't come in without a warrant, because the Fourth Amendment requires that under those circumstances, they can't come in and search without a warrant. All right, so there you go. Remember that distinction, though. I always come back to that because I like to test it. If the search is done by someone who's not a representative of the government, that's not a violation of the Fourth Amendment. Right? Lots of people don't realize that. In fact, if you asked anybody as you're walking down the street, they'd probably tell you that no one can search their stuff without a warrant. That's not quite true. Excuse me. All right, so the Fourth Amendment protects us only from government searches that occur without a warrant. All right, there's our Fourth Amendment slide. So when is the Fourth Amendment violated? When it's a search by the government in a place where you have an expectation of privacy. They can't do that unless they first have a warrant, or there's an exception to the warrant requirement, like an automobile exception. All right, so watch for that example that I just gave on an exam. Your landlord comes in and searches your apartment while you're at school. Has the landlord violated your Fourth Amendment rights? The answer is no, because the landlord is not the government. It's not a search by the government. All right. Okay, so there's our Fourth Amendment. And of course, we've made it relevant to business, because remember, law enforcement often would like to come in and search businesses for evidence of crimes. Can't do it without a warrant. Let's talk about the Fifth Amendment, another important part of the Bill of Rights. And here's what I want to talk about. It includes all of those things on the slide. I want to talk about the first one. You have a right under the First Amendment not to be forced to incriminate yourself. That's, the Fifth Amendment right not to incriminate yourself. And it's a strange addition to our Constitution. And here's why I think it's strange. If you think about it, who can invoke the Fifth Amendment? Well, someone like this. The police asked, did you rob the bank? Answer: I refuse to answer that question on the grounds that it might incriminate me. Can I say that? Yes. Notice that I'm being accused of a bank robbery. So let's change the example. Let's assume I did rob the bank. And I took all the money. And somehow the police find me. And they ask me this question: did you just rob the bank? My answer is, I refuse to answer that question on the grounds it could incriminate me. Notice that the Fifth Amendment, right against self-incrimination, protects the bad guys. Only people who are guilty can invoke the Fifth Amendment. In other words, if I'm asked that question after the robbery, the only way I can seek the protection of the Fifth Amendment is if it's true that my answer to the question would incriminate me. In other words, the only time I can invoke the Fifth Amendment would be as if I really did rob the bank. So the Fifth Amendment actually protects the bad guys from having to incriminate themselves. Why in the world would the Founding Fathers put that kind of protection in our U.S. Constitution? And I think the answer to that, again, is history. When we were just colonies of the British government, and when they started to believe that we were trying to become independent, what they would do is they would arrest people, colonists, for no reason, and then bring them to, usually an army barracks, and force them to confess that they'd been planning a revolution. And then they would confess, and then that confession would be used to convict them of treason, and often they'd be executed. And the Founding Fathers thought that was unfair. Even they thought guilty people should have the right not to have to incriminate themselves. So they had long experience with the British government's abuse of their power over the colonists. So when they came time to write our Constitution, they wanted to make sure that that didn't happen in our country, so that even criminals can refuse to be forced to incriminate themselves. And so I think that's why we have that part of the Fifth Amendment. I think the colonists suffered some very bad experiences under the British authorities. So they wanted to make sure that even bad people were protected. All right, so you have a right under the Fifth Amendment not to be forced by the government to incriminate yourself. All right. Remember, again, you're only protected this way if the government tries to force you to incriminate yourself. This is the pattern, isn't it? First Amendment only protects us from the government. The Fourth Amendment only protects us from the government. And the Fifth Amendment only protects us from government conduct. And so another thing happened as time went by. For a long time in our country, for really almost 200 years in our country, people were being arrested for crimes and asked by the police, did you do it? And many times the people would say, yes, I did, because they didn't understand that they had a right under the Fifth Amendment not to incriminate themselves. They thought they had to confess. And so for almost 200 years, we probably can't count the number of times people were arrested and confessed to the crime, not knowing that they didn't have to confess. And so I would have to believe that many, maybe thousands of people actually were convicted of crimes and went to jail solely because they confessed. The only evidence against them was their confession, most of which confessions would never have been given if those people understood their rights under the Fifth Amendment. So finally, in the 1960s, the Supreme Court had a case called Miranda versus Arizona, where finally the Supreme Court said, enough is enough. When people are arrested by the police, before the police can ask them questions about whether they did the crime, the police have to advise them of certain rights. One of those rights is the right to remain silent and not incriminate yourself. The other right is the right to an attorney. So from that point forward, I believe the case was in 1963. From that point forward, when police arrested people, before the police could question them about their crimes, the police had to inform them of the so-called Miranda warnings. And so from that point forward, I would speculate that many defendants chose to invoke their Fifth Amendment right and not incriminate themselves, chose not to speak to the police, and therefore forced the government to prove the case against them without the benefit of their own confession. I guess the sad part about this is that all of those people arrested before 1963 may have confessed to crimes that they didn't have to confess to. They just didn't understand that they had a Fifth Amendment right against self-incrimination. So it took our court system a really long time to realize that most people in our country don't understand that they have a Fifth Amendment right against self-incrimination. So they foolishly confess to their crimes, often in cases where otherwise there would not be enough evidence to convict them. So I guess maybe it's one of those injustices that occurred in our country for a long time. It's not the only one, certainly, but it's one of those among a number of them that occurred. And this one, really, think about it, just through ignorance. People didn't understand they had a Fifth Amendment right, so didn't know what to do when the police started questioning them. So how does this relate to your business? Well, here's how. For the same reason we talked about the Fourth Amendment, some government entity, a law enforcement entity, wants to investigate your business, comes to you and asks you, did you cheat on your taxes last year? And of course, you know in your heart that maybe you did. Can you refuse to answer that question? Yes, you can. You have a Fifth Amendment right against self-incrimination. If you're arrested one night and the police think that you're driving drunk, they arrest you and they ask you, were you driving drunk? And you say yes. And they're going to use that statement against you at your trial. But wait a minute. They violated the Miranda rule. You were under arrest, and before they asked you any questions, they didn't give you your Miranda warnings. So when you get to trial, you can ask the court to suppress your statement that you were driving drunk because you weren't given Miranda warnings. And by not being given your Miranda warnings, the police violated the Fifth Amendment right against self-incrimination. And so any statement you made will be suppressed, can't be used against you in court. So you can see that the protection of the Fifth Amendment is important for everyone, even people who are in business, not just bank robbers and murderers, but people in business. You have a right not to incriminate yourself. And the police, the government can't take that away from you. You can only give that right up voluntarily. All right, so there you go. That's the Fifth Amendment right against self-incrimination. Now, the Fifth Amendment also includes, and by the way, there's lots of reading in the book about the other three things on the slide here. Double jeopardy. You can't be tried twice for the same crime. You can read more about that in the textbook. The one I'm focusing on for this class and for our exam will be the Fifth Amendment right against self-incrimination. So be aware of that. What is you're entitled to certain due process rights. Yeah. You can't be convicted, for example, without a fair trial. If you are, then your due process rights have been violated. The takings clause, that allows the government to take property for a public purpose. Probably seen this. The city wants to build a new football stadium. There's lots of houses on the site where they'd like to build. Well, can they take those pieces of property away from the homeowners without their consent? Yes, as long as they pay them compensation. Because we needed to take those houses for a public purpose, to build a football stadium, which would bring more tax revenue and all kinds of other revenue to the city. Right, so that's the takings clause. I'm not real concerned about that. I don't imagine that's going to be part of your business life someday. But certainly, if the government, police, a criminal investigator from some government agency comes knocking on your door someday and starts asking you questions about a potential crime, remember your Fifth Amendment right against self-incrimination. All right, so there's our Fifth Amendment. So we've covered 3 important amendments. By the way, the first 10 amendments, they were part of the original Constitution. So they weren't later amendments. They were part of the initial Constitution. So it was the U.S. Constitution plus the first 10 amendments. That was all part of the same document. The next part of the Constitution I want to talk about is the 14th Amendment. This was an amendment an amendment to the Constitution that occurred long after the original Constitution was ratified. This actually, this amendment occurred right after the Civil War. So again, history is important for us to understand how these things work. So why do we have the 14th Amendment? Well, here's why. We fought the Civil War in large measure over the question of slavery and the expansion of slavery. And, as you know, President Lincoln, he signed the Emancipation Proclamation, which freed the slaves. And of course, the southern states, the Confederate states, they didn't give any authority to President Lincoln. And so when he freed the slaves, they just said, we're disregarding that. Our slaves are not free. And so ultimately, the Union won the war, the Civil War. The Confederacy was dissolved and surrendered and dissolved. So was welcomed back to the United States. And so Congress thought that, wait, we need some protection for people against discrimination. So the 13th Amendment freed the slaves formally under the Constitution. But Congress, after ratifying the 13th Amendment, thought, it's one thing to say slavery is now prohibited, but aren't the African Americans still going to be discriminated against by white people? And so the 13th Amendment, again, prohibited slavery, but it didn't prohibit discrimination. That's why we needed the 14th Amendment. The 14th Amendment really ensured that all people get the equal protection of the law. In other words, the government, under the 14th Amendment, the government is not allowed to discriminate against people based on their race. Right? So again, history tells us a lot. We fought the Civil War. We ratified the 13th Amendment that prohibited slavery forever in our country. And just to protect people who had been freed, we then ratified the 14th Amendment, which protects all people from discrimination by the government. Notice, by the way, again, I've mentioned the government. The 14th Amendment protects all of us from discrimination by our government. So if a private person discriminates, is it a violation of the 14th Amendment? Answer, no. So let me give you an example. Let's say you owned a hotel in Virginia in 1875, 10 years after the Civil War. Two things you knew. Number one, you knew that the 13th Amendment had been ratified and slavery is now prohibited, illegal. You're also aware that the 14th Amendment has been ratified. So you're operating your hotel one day and an African-American family comes in to lease a hotel room, rent a hotel room. Your answer is, we don't rent to African-Americans, get lost. Have you violated the 14th Amendment? Answer, no. You're not the government. You're a private business. The 14th Amendment does not prohibit discrimination by private businesses based on race. So you would not be in violation of the 14th Amendment, which might, strike you again as being a little strange. It seems like all of these amendments to the Constitution, they all only apply to the government and the government doing bad things. Nowhere among any of the amendments that we've discussed so far do they involve prohibiting bad things by private people. So if you think about it, if you ran a hotel in Virginia today and a African-American family came in to rent a hotel room for the night and you said, no, we don't rent to African-Americans, would you be in trouble? Well, you're not in trouble under the 14th Amendment. But since that time, Congress has passed many laws prohibiting discrimination. So although you wouldn't be in violation of the 14th Amendment, you would be in violation of several federal laws that prohibit discrimination by private people based on race. So yeah, discrimination like that by private people is now illegal, but only by statute, only because a law was passed making it illegal. It's not illegal under the 14th Amendment because the 14th Amendment only applies to government acts of discrimination. All right, so watch for that one on an exam. I could give you that same example that I just gave. You operate a hotel. You're the private owner of a hotel. A black family comes in to rent a room and you deny them. Are you in violation of the 14th Amendment? No. Would you be in violation of federal anti-discrimination laws? Yes. Would you be in violation of state anti-discrimination laws? Yes. Right. So make sure you make that distinction. Right. Okay. So that's just, I've selectively gone through the certain amendments to the Constitution because I think those are really important and I think they relate to business. And by the way, how's the 14th Amendment relate to business? Hey, well, here's one. How about this? You are now going to hire people to work for your business. And you refuse to hire anyone of color. Right? Have you violated the 14th Amendment? No, because you're not the government. Have you violated federal and state law against discrimination in employment? Yes. In fact, we will talk lots about employment law later on in our semester. We're going to have a class on employment law and employment discrimination. Just remember that when it comes to private employment discrimination, in other words, employment discrimination by private businesses, all right, that discrimination is regulated not by the Constitution, but by statutes, by laws passed by Congress and by the states. All right. Okay. Okay. So we have a lot now that can be the subject matter of exams. So as I've told you in last week's video, we're going to have one exam and then a final exam. I would be prepared on that first exam, exam one, to be in a position to discuss each of these amendments that we've talked about today in class. I think they're important amendments. I think they're very relevant to businesses. And so that's why we've talked about them. And so just to make sure that you do understand them, that's why I test you. The school requires, here's what this testing is all about. The school says, look, we got to be sure that the students are actually learning. And so to figure out whether they're actually learning, we have to test them on their ability to, explain certain concepts that have been discussed by the professors. And so really exams are a way to assure that you're learning something. And the only way that I can know that you're learning something is by reading your exam. So I can talk all day long and just hope that you're understanding. But that's, the school doesn't let me do that. I also have to test you to make sure, to be assured that you're learning. All right, so that's why we need the tests. I don't like them, you don't like them, but they're required. All right. Okay, just to finish things off, a few more slides. We've talked about this. There's a separate set of state and federal courts because both states and the federal government pass laws. So legislatures pass laws in states, Congress passes law for the federal government. And so in order to enforce those laws passed by, for example, the states have created these state court systems. Right? So it makes sense that there's going to be, if there's separate federal and state law, we need separate federal and state court systems, right? That's no surprise. The last thing I want to talk about is what I mentioned at the beginning here, alternative dispute resolution. By the way, I think we're about at 2 hours. That's about how long I like our lectures to last. I think much beyond 2 hours and, you start to have trouble, retaining your attention span. So I generally go 2 hours without a break. And 2 hours is my target time. All right, so we're just about there. So we have really just one more slide to talk about. And here's what it involves, as we sort of mentioned earlier. There's lots of times when you would have the right to go to court to enforce your rights. So for example, let's say that you own a business, you entered into a contract with another business and they breached the contract. They violated the contract. You ordered some goods from them and they didn't deliver them. Have they breached your contract? Yes. Can you go to court and enforce your contract rights and ask the court to give you damages for for what was caused when the other party breached the contract? You can do that. And of course, as you can probably imagine, that requires that you probably gonna have to hire a lawyer, which lawyers are expensive. You're going to have to go to court someday, which means that instead of running your business, you're going to be in court sitting there. If you actually go to trial, you probably have to be present for the trial, which could take several days. All of this is costly. And by the way, when you go to court, you may not win. That's even a more bitter pill. Not only do you feel like your contract was broken, but you go to court and you don't succeed in your lawsuit. And you've spent all that money for what? So should we try to avoid litigation? And even if the only reason to avoid litigation is to save money, think about this. This is a business decision you have to make. You have to ask yourself, what might I recover if I go to court? What damages might I recover versus how much is it going to cost me to go to court? So if it costs you $10,000 in attorney's fees and other fees to go to court, and you're only trying to recover $5,000, it doesn't make any sense, does it? So really, in many ways, the decision to go to court and enforce your rights is really a business decision. It's a cost versus benefit. So should we develop systems, formal systems, for avoiding having to go to court? And the answer is yes. And that's alternative dispute resolution. And there are different kinds of ADR, alternative dispute resolution, different kinds, which you've read about hopefully in your textbook. All of them are there. So let's assume I run a coffee shop. I ordered coffee from my coffee supplier and he doesn't deliver. Of course, when I ordered the coffee, we entered into a contract. I would pay a certain amount and he would deliver the coffee. He's broken our contract. He's breached our contract by not bringing the coffee. Could I go to civil court and sue him for breach of contract? Yes, I could. Yes, I could. But here's some reality. It's going to be expensive. It's going to be time consuming. I may not win. And, if I go to court and sue this guy, he's probably not going to want to be my coffee supplier ever again. We're going to be enemies. Maybe I want to retain that relationship. Maybe I don't want to destroy our relationship. Maybe we can work this out without becoming enemies. So here are the possibilities. Think about this. Couldn't we just try to negotiate a solution? I call him up. Can we work this out? You've cost me a certain amount of profit because the coffee wasn't here and I couldn't serve my customers. You owe me some money for that. And of course, the coffee supplier might say, well, I don't want to pay any money. And you explain to the coffee supplier that if we have to go to court, it's going to cost him money too. So why don't we just work this out? Why don't we negotiate a solution? That's always a possibility. As much as it may anger you that your coffee hasn't arrived, you're a business person. You got to put that aside and you got to be thinking like a business person. You have to come up with a solution that you can live with. Now, if you want to sue the guy out of principle, that's fine. It's just going to be an expensive principle that you're trying to enforce. So think about negotiation. You also read about something called, mediation. What's that? That's voluntary. Parties just say, maybe if we get a third person to listen to the story, maybe the third person could give a recommendation about how that person, so it's the mediator, thinks that we should work this out. In other words, we have trouble talking because we're both angry. What if we bring in a mediator who will listen dispassionately to the story and then recommend maybe a solution to us? Maybe that's a better way for us to come to a resolution. The thing about mediation is that it doesn't bind the parties. In other words, if the mediator decides that I'm wrong and I disagree with that, I can still go to court and sue the coffee supplier. So mediation is just an attempt using a third-party mediator to work out a dispute. Sometimes it works, sometimes it doesn't. But either way, it's not binding on the parties. They don't have to accept the mediator's recommendation. And that's what separates mediation from arbitration, right? The parties might want to agree to arbitration and hire an arbitrator, like a private judge, because it's cheaper and it's quicker and it's less time consuming than going to court. But with arbitration, generally the parties are bound by the decision of the arbitrator. So if the arbitrator rules against me, I'm bound by that. I can't go to court and sue. I'm stuck with that decision. So if I agree to arbitration, chances are then I'm bound by the arbitrator's decision. I've avoided some of the court costs of going to court. It's probably been a quicker resolution, but in the end, I'm bound by the arbitrator's decision. So there's the difference. So watch for a question on one of my exams where there's a dispute between two business people. And I might ask the question, what's the best way to resolve this dispute? And your answer could be as follows. Well, they could try to negotiate. If that doesn't work, they could try mediation. If that doesn't work, they could try arbitration, or they could just forget about all three of those and just go straight to court and bring a lawsuit. Right? But you're going to have to explain why you chose that particular form of ADR. Right? So why did you choose mediation? Why did you choose arbitration? Okay, so just, my questions are always essay questions. And they always ask you to explain your answer. So if you, for example, answer the question by saying, I would choose arbitration, you then have to explain why you chose arbitration and not one of the other forms of ADR, or why you chose not to go to court. Right, so it's pretty straightforward. All right. Okay, so there's our lecture for this week. Again, be prepared to do the reading ahead of next week's lecture. And I guess the word of warning I have for all of you is make sure you listen to the lecture, the video lectures. Those are critical. You can't do well in this course without doing that. You've already seen during this lecture me point out that certain examples I'm using could end up just like that on one of the exams. So if you hadn't listened to the lecture and you hadn't heard that example before, you might not do as well on that question on an exam. Right? So it just makes logical sense. Right? So I'm here lecturing you to help you, to make you a better student, a better business person. I'm just here to help. I'm not here to punish you and make you listen to me. I'm here to try to help. All right, so that'll do it for today. I will see you again next week under the same format. There'll be a video lecture. Make sure you do the reading ahead of the lecture. And again, feel free to reach out for me by email if you have any questions or other things you'd like to discuss. I'm available. All right. Take care of yourself. Stay healthy. See you next week.